Start. Jai Hind. This is Advocate Charanjeet Chanderpal, uh, President of a NGO known as the Nitya Law Society. Our NGO does a lot of research on law and specifically those laws which affect the masses. When we were given to understand that a law was passed on 24th September 2020, we started a extensive research in our NGO itself. Initially, there was a hue and cry as regards this law from the state of Punjab, from the state of Haryana, from the state of Himachal Pradesh, and some prosperous farming states. Initially, we were not expecting that this law would be anti-farmer, due to which our studies were very, very slow. And we did a lot of research before arriving at our conclusion. It may be appreciated that we are not against any particular government. If some person is having a feeling that by objecting to the present farm laws, which we choose to object after a detailed, extensive study, that we are against a particular government or against Mr. Modi or against the finance minister or against the agricultural minister, it is a misgiving. We have done our research and based on an extensive study by 60 to 70% members of our NGO who are lawyers. We are a group of 60 to 70 people, amongst which 45 of them are lawyers. We have decided to oppose this farmer bill. It is the same NGO which supported the government in the Article 370 issue. And with some modifications, it also supported the CAA aspect. And although the demonetization was not a huge success for the government, we did not raise much of an objection because even despite it not being successful, it was say about 10 to 15%, some amount of black money was roped in. Though it had got a number of flaws, it caused a number of hardships on the people. People and old people were stranded, a lot of currency goof-ups occurred, a lot of banking problems occurred to people. But then we saw the macroeconomic thing and we let it go. Specifically after 15th and 20th October, and in the first or second up to first week of December, the amount of uproar that was created by the farmers of Punjab, Haryana, Himachal, and some prosperous states of farming made us compelled to analyze critically this aspect of the farmer law. Finally, with respects, I may confess that it did create an impact on our members. The protest death done by one of the Sikh saints, Sant Baba Ram Singh, has really moved not only our NGO but also people all over India, and it was all were compelled to have a relook at it. And based on the amount of protests and the amount of data which has been coming in from time to time through various newspapers, through various organizations, we have had to analyze this. And believe me, with greatest respects to Sri Narendra Modi and his team, we have provided for all kinds of benefits of doubt in interpretation of the farm laws which have been passed. This is the copy of the farmer law, and we have done the study. This is our study material. This is the entire study material amounting to about 45-50 pages, which we have done. And we have also perused through some of the Supreme Court data which has been forwarded to us. Now let us see what are the objectionable parts, or rather, what is the farm law about? In the first place, let us divide the country into the states it has. Now let us see the per capita agricultural income of Punjab, Haryana, followed by some other prosperous agricultural states. The per capita agricultural income of Punjab and Haryana are 23 to 24,000 rupees per agricultural household, followed by Haryana, which is about 18,000. And then the figures slip right up to 10,000, 5,000, and 4,000. What happens as of date, or rather prior to the bill being passed, converted into law? It was basically the APMCs which were having a minimum supply price at which basic crops would be sold to the farmers, would be purchased from the farmers, sorry, and it ensured a minimum price level. Now, if one sees an example of Punjab, the wheat crop, which is sold to these APMCs at a particular price, it takes care of their minimum prices, their costs, everything, and it gives them some amount of profit. It may be noted that agriculture cannot be equated with any other kind of a service, like, for instance, railways or, for instance, power supply. It is basically the starting point of subsistence. In an agrarian country like ours, where we survive even today on 60 to 70% on agriculture, we cannot obviate from the fact, or we cannot obviate the fact that agriculture remains an essential commodity service for us to survive. When one handles with an agricultural law, naturally each and every state which has its own demography of rivers, own demography of wells, own demography of customs and traditions, all these have to be kept in mind before implementing any macroeconomic agricultural change. The government implemented RERA. Now, RERA was for flats and apartments. Even there, in fact, there was a restriction in the constitution, but they enacted a central law. Okay, it was for the benefit of the people. Railways are being thought of being privatized. That also we can understand. The government got in GST, though it did cost 18-20% of the billing and various kind of price mechanisms which were not clear. But still, by and large, the economy would benefit. There would be a standard rate applicable. It would lessen the need for income tax, so on and so forth. And we were very, though we were very skeptic, but we accepted. Now, what is objectionable? The problem is that the credit which till down was being given, maybe heard carefully, by the center to the state and from the state to the state APMCs. That credit has been withdrawn. If you withdraw the credit of an APMC, that APMC will not be able to give you any kind of support. They will not be able to purchase them at the minimum supply price. Now, what happens when you don't purchase at the minimum supply price? Let me tell you, even today, when we see the non-paddy crops, the apart from the wheat crops and those crops which are provided with which are protected under the MSP, there is a huge fluctuation in rates. The rates vary sometimes for some crops from 14 rupees a kilo right up to 100 to 110 rupees a kilo. It basically becomes a very market driven and a very um, trade driven kind of an enterprise rather than an essential commodity where the farmer should be protected. Even today, when those non MSP governed crops are being sold out, the farmers are exploited. Now, when we see a major chunk of a particular crop, for instance, wheat, not being protected by MSP, what happens? Finally, it takes away any guarantee or any kind of assurance to the farmer who till now was being assured of an MSP from the government. The government MSP, though they say that we are going to provide for the MSP, but when you withdraw credit, when you withdraw credit from the center and the state to the APMCs, when you withdraw credit to any state about agriculture, finally what happens is the farmer would be forced to seek his purchase from the private people. The private people have now been given, the private houses have now been given a, a, I would say, a free hand into buying the farm produce from the farmers. What would happen is, in a given situation, that if a farmer would like to sell to the private purchaser, he would be at the mercy of the private purchaser. The private purchaser would determine the price or may not determine the price. Under the second law which is passed, the first law which is passed in this regard is the Farmer Empowerment and Protection Agreement on Price Assurance and Farm Services Act. There will be a farmer agreement which would be entered into by the farmer as well as with the purchaser, the private purchaser. Now, what will happen as a result of this? Farm agreements based on some crops which the private purchaser may not be interested in buying. He would determine the price. If the farmer would not sell it to him, then he would have to wait, vouch for another particular purchaser, wait for some time, again vouch for it. In the meantime, in medieval period, what will happen is the farmer may not have the funds, and in order to in order to I would say succumb to the circumstances, he may be tempted to sell at a very lesser price. So the protection which was guaranteed by the state by way of the MSP through those state APMCs has been withdrawn. They say that APMC will be there. APMC is going to be a particular benchmark, or there will be benchmark level set, and choice can be made between APMC as well as the privaters. But when one goes to see the private purchasers would be at a much better bargaining power than the APMC, which is not going to have any credit or kind of a strength to assist the farmers. Now, this situation is going to arise. Now, let us see the government's angle, what the government says. The government says that in all over India, there are some sectors, or rather 60, 70%, 80% of the states where the farmers are not getting this MSP also, and the middlemen who are there, who are procuring and acting as middle agents between the farmer as well as the government, the APMCs. Those middlemen take away a lot of the cut, and they give very little to the farmers in hand. Fine. Now, my question is that in those states where there is less exploitation or no exploitation, or where there are enterprising people who bargain properly with the middlemen, like we have in Punjab, Haryana, northern part of Rajasthan, a little bit of Himachal Pradesh, and those prosperous states of the farming sector, where we have a lot of farmers selling through middlemen, and those middlemen, in fact, provide a lot of finance and assistance to the farmers in the medieval period when the payments are to come. Those particular farmers and those particular states will be at a staggering loss. It will affect their households. Finally, what will happen is the middle income and the lower middle income farmers who are surviving on the MSP, on the wheat, paddy, and various things, they will have to bear the brunt. They will have to basically, a stage will come that they may have to sell off their farmland. A stage will also come that they will have to enter into at any particular price and purchase agreement, which will be enforced upon them by the private people. As a result of this, what will happen is there could be a rise in the number of NPAs of the banks. There could also be a rise in the deaths of farmers who may commit suicide. All the investments and the technology advancement investments which many farmers of Punjab and Haryana have done in their particular farms would stand demeaned. It would be in a loss and loss situation. And this is what the agitation from Punjab, Haryana, and some states where farming is a very prosperous sector is about. Now, coming to the aspect, now there are some kind of agents also which the government and some kind of agencies which the government has which the government has appointed, and those agencies are, there are some other parties also which have been permitted, and those agencies have been given an official authority to act as mediators in the farming sector. These agencies would definitely mean the private agencies, and those private agencies would mediate with them. Now, what happens is that this kind of a mechanism where private people are going to purchase, there's going to be a private agency which is going to compete with the state APMC. What will happen is naturally the private sector, which will comprise of the industrialists, will be at a very strong monopolizing position. It would be reverse in specifically those states where farming is a very prosperous business. It may benefit some states where farming is not a prosperous thing, where farmers are actually are being exploited all these times. So on one hand, we have those states where the farming policy may benefit, but then we have also those states where the farming policy will be taken aback seriously. Now we come to the statistical comparison. Statistically speaking, Punjab, Haryana, and the northwestern provinces, they have been contributing a lot, substantially, to the extent of 25-30% of the agricultural produce of the country. These states are the agricultural capitals of India. Before this kind of a policy was enacted, the government should have consulted these states. Now, coming to the constitution, I'll come to the legal aspects of this a little later again. Now, let us see the constitutional validity of all these three farm laws which have been passed. Astonishingly, even the Essential Commodity Act has been amended. Now, the biggest objection, which I, as a lawyer, though I have supported this government on two, three issues in the past, we did hold marathons, we did give speeches for the successful implementation of Article 370. We also took out 10 intervention applications at the Supreme Court in the name of Nitya Law Society. Our names are there in the reported judgments of the Supreme Court also, where we intervened and we supported the government's initiative for Article 370. We also supported to some extent the CAA, though not entirely. Now, these three laws which have been passed, according to me, are ultra vires constitutional. They are anti-constitutional. These follows are the Farmers Empowerment and Protection Agreement and On Price Assurance and Farm Services Act 2020, Farmers Produce Trade and Commerce Act 2020, and the Essential Commodities Act, the amended portion 1955, which has been amended along with these two other laws. Why unconstitutional? Let us see the existing framework of the Constitution. The Constitution is divided in terms of the powers vested between the legislature, the executive, and the judiciary. As far as the central government is concerned, we are concerned with list 1 of the Constitution. As far as the state governments are concerned, they are concerned with list 2 of the Constitution. And as far as the concurrent list and the list 3 is concerned, where both center and state can enact provisions. Agriculture, surprisingly and actually, does not fall within list 1, which means that the central government on its own cannot and cannot make any policy on agriculture without the assistance or without taking into consideration the state, because in list 3, item 33 of list 3 deals with the agriculture, where both center and state have to make policies. Item 14 of list 2, which is the state government list, again concerns with agriculture. What the government would say is that we are concerned with trade, commerce, and various things which is permitted under list 1. If the framers of our constitution, who made the constitution, had any intent of including agriculture within the central government list, then it would have specified there's trade commerce pertaining to agriculture. It is a generic term, trade and commerce. List 2 deals with a specific term of agriculture, which is mentioned at item 14. And list 3 says both central and state government. Item 33 deals with agriculture. Now, let us see the police laws. We'll make a comparison of the agricultural law with those laws where both state and center can enter into any kind of a lawmaking process. The state law, in terms of the police law, when a police law is made, the customs, traditions prevailing in those particular states are taken into consideration. The states have the power of amendment, and after amending, they make the laws. State list, the list 2, there's no question of government interference. So when this particular law, these particular 2 laws, as well as the Essential Commodities Act and the sister laws were enacted by the parliamentary process, with greatest respects to this particular government, they should have necessarily held a debate before calling for passing of these laws. As such, the center does not have any power to intervene in the aspects of agriculture. If it has done so, it is utterly unconstitutional, and we all must challenge this move of a government entering into the constitutional framework. You cannot change the basic framework of the constitution. It's a age-old settled law by the Supreme Court itself. The Supreme Court, it seems, has also asked the AG to appoint and to consult a committee before all this snowballs further. Now, we will also see as to how this particular law, all these 3 laws were passed. And we did not expect this from the government, a government which we loved, a government which we have supported, a government which has given us a very stable government, a government which has given us some policies which are good. We did not expect such a kind of a policy from the government which would be so unconstitutional and done in a way which basically raises doubts. Now, when was the bill introduced? It was introduced on 3rd June or 6th June of 2020 in the parliament, and it is quietly passed on 24th September 2020. Everybody knows that this was the corona pandemic time. Most of the people were busy. Many parliamentarians also missed out, may not have come. A Zoom meeting or some kind of a process may have been held, and this law has been passed. Would it not be proper for Mr. Modi, with all the respect that we have for him, as well as the Council of Ministers which he has, that this law should have been passed after everything returns to normalcy? The preamble and the purposes and statement and reasons of this law says that this is passed in COVID-19 pandemic because the farmers' interests have to be taken care of. Now, what interests are going to be taken care of when there is social distancing? There are so many restrictions, as it is the country is reeling under pressures of social distancing and physical contact. These are basically only ways and means of passing a law. This raises doubt. Till now, we did not raise any doubt on the government. We were all supporting this government because it has given a stable government with all its plus and minus points. But this kind of passing of a law, it has hurt the sentiments of not only the farmers of Punjab, Haryana, and those affected states, but all over the people have basically started questioning as to how the majority seats and the majority number of seats are going to have such a say that without any particular opinion from the public, a law is passed which many people feel is going to adversely affect. Now come to another aspect which the farm laws are indicating. One is unlimited storage by the private houses, no cap on pricing. Further is an aspect that the SDM, the SDO, the Special Divisional Officer or the Special Divisional Magistrate, as we have in the land laws, he will have the power to settle the disputes. And appeal will lie to the collector. And from the collector, naturally, it will go to the commissioner. And from the commissioner, it may go to the land revenue tribunal or particular tribunal. And from the tribunal, again, it will have to go to high court. And civil court jurisdiction is prohibited, which means that the farmer cannot go to the civil court. He has to follow that process of law within the land revenue, within the land revenue code, like we have in the Income Tax Act, like we have in the GST law. And then only in the writ jurisdiction or in the revision jurisdiction, he has a remedy. Of course, there are laws that the law does state that there is protection for the farmer, that his land shall not be confiscated. His land shall not be this thing. But when you see the amount of private interest and the bargaining and the monopoly position of the private interest that has occurred, it is very, very natural that the farmers would succumb to the demands of the private sector. Email trade, trade by e-commerce, and so many aspects will again throw upon a Pandora's box of what is being promised and what is being supplied. We definitely need to have a relook at these farmers' laws, and we cannot have this kind of a law in a state where we have so many states and each and every state may have its own problems. To my knowledge, Punjab and Haryana farmers are already pro-farmer. They are already pro-agricultural states. They can be called as the agricultural capitals of our country. In these kind of states, protection of farmer would be meaningless. So it is my humblest request that there are provisions have gone through the act. There are provisions where the central government can take out notifications. Those notifications can be brought in immediately, forthwith, to exempt and exclude some states from the operation of this law. This is my first suggestion. My first suggestion is to implement the notification process and notify some states which will not be governed by this law. Number two, since it is in the concurrent list, my humble suggestion to Mr. Amrinder Singh, the Chief Minister of the state of Punjab and Chief Minister of state of Haryana, and various states where they are not agreeing to the farmers' law, is to implement their own notifications, to implement their own laws under the state list, which is 14, and to implement a law under the concurrent list, which is 3, and to make and pass appropriate notifications by their majority of their parliament and negate the processes which are found derogatory to the farmers' interests. Those kind of notifications can be issued, those kind of modifications can be done in order to protect the interests of the farmers. And I don't see any kind of harm in doing it. It can be done without repealing the laws. And if necessary, and if the government has the magnanimity, it may stay the operation of this law, call once more for a parliamentary debate, take a referendum from all the people in the public, and see which states are opposing it and what are the reasons, and make it partly applicable to those states. Like in Hindu Marriage Act, we have some states which follow the Marmukatayam law, some states which follow the Dayabaga Hindu law. That way, we can have a particular mechanism by which some states which are already having a prosperous farming sector may be excluded from the operation, A, by notification by the central government itself, B, by passing of the state government laws. One cannot have a situation where the privateers will now fiddle around with aspects of essential commodity. If it happens, may God save the economy of this country. Like the air tickets, our wheat prices also would be fluctuating from X to 10x one day, 3x, and then there will be no certainty left in the economy. It is my humblest request to Mr. Narendra Modi. It is my humblest request to all the state governments to either ensure that a notification is issued with respect to some states and exempting some states from the operation of this law, or the state government passes their own laws with some notifications, like we have under the CRPC, where some provisions are allowed by some states, some are not allowed by some states. And within such a framework, without affecting the interests of the farmers in Punjab, Haryana, and those states, those aspects are taken care of. And either this law is repealed and enacted with these kind of amendments, or it may be applicable to those states which are accepting it, and not applicable to those states which are not accepting it by way of the notification and the state law amendments. That's all that I wish to state. I hope and trust this government would do something about it and would have mercy on all my farmer brethren whose food we Indians eat. It is the blood of the grains that we are living. It is not the blood of the industrialists that we are breathing. It is the blood of those people who toil for us on the farms and the grains that they make that we eat, the grains that they make and the soldiers on the frontiers fight. It is their life and blood. We are an agrarian economy. We are a macroeconomic agrarian economy, and we cannot brush aside the sentiments and the reasons and the protections of the farmers. I have given a very neutral kind of a of an analysis without getting sentimental about anything. Jai Hind, Jai Bharat, Vande Mataram. Thank you.